Welcome to McKenna & Co, and thank you for trusting us with such a difficult time for you and your family. The purpose of this video is to give you an insight into the process and to give you comfort of what will happen at each step of the process. We will require the following documents and information from you. 1. We will require a death certificate or an interim death certificate. Without a death certificate or an interim death certificate, the process cannot begin at all. For example, any financial institution where the loved one held accounts have to be satisfied that the account holder has died before they will disclose the value held in the account. Also, the probate office won't issue a grant of probate or letters of administration until they're satisfied that the death has occurred. 2. Find the original will. The will is often among the deceased's personal papers, or maybe with your former or current solicitor, or with a family member. 3. Identify the personal representative. This is either the executor or the administrator. The executor will be apparent from the terms of the will. If there is no will, or if there's no executor has been appointed, or can it be identified under the will, then the administrator has to be identified. This is governed by the Succession Act of 1965 as amended, and it's usually the deceased next of kin. Priority is given in the following order: the spouse or civil partner, child, parent, brother or sister, and then more distant relatives. 4. Make sure any house or property is properly insured. This step is often forgotten. If the deceased left a house which is now empty, it's important to notify the insurer of the change of circumstances to make sure that the policy remains fully valid and up to date. 5. Identify the deceased's assets. The following type of information may be needed: bank or other accounts, full account number, bank details, in order for your solicitor to obtain confirmation from that bank of the balance as of the date of death. Residential or other property, a formal valuation from an estate agent will need to be carried out. Shareholdings, a copy share certificate will need to be valued. You need to identify the personal property such as a car, jewellery, antiques, and get those valued. You also need to provide details of life policy and pension details. 6. Identify any liabilities which have to be paid from the estate, such as funeral and wake expenses, headstone costs. Identify all debts or potential liabilities, including guarantees that may be owed to the estate. We need to compile any outstanding utility bills, due date for insurance payments, and local property tax liabilities. Identify if any income taxes or taxes are due. It may be necessary to obtain tax advice. 7. Identify any beneficiaries. It is the will that will tell you who the beneficiaries are, but if there's no will, the persons who are entitled to a share of the deceased estate is governed by the Succession Act of 1965. So, for example, if the deceased is survived by a spouse, civil partner, but no children, the spouse or civil partner gets the entire estate. If the spouse or civil partner has children, the partner gets 2/3 and 1/3 is divided equally between the children. If there is no spouse or civil partner or children, it's divided equally or entirely to one parent if only one survives. Children with no spouse or civil partner, it's divided equally between the children. Brothers and sisters only, it's shared equally. The children of the deceased brother or sister take their share. Nieces and nephews only, it's divided equally between those surviving. Or other relatives, it's divided equally between the nearest equal relationship. 8. Compile other administration information, such as the PPS number of the deceased, the name, address, and PPS number of each beneficiary. If there are any non-resident beneficiaries, we must obtain an Irish PPS number for them. We can apply for the Irish PPS number on their behalf once documentation are completed. We will need to know, did the deceased avail of the nursing home support scheme? Do you have the deeds to the house, as they may be needed to complete the application? We need to obtain details from all beneficiaries of any prior gifts that they received from the deceased or inheritance received from any source. Once all of the above has been completed, the application can be prepared, submitted to the Revenue Commissioners. This is an online submission. The probate office is a paper application. The timeline will be 20 weeks to obtain the grant of probate or administration from the probate office from submission. Once the grant does issue to your solicitor can then call in all the assets from the estate and pay out to the beneficiaries. Once all the beneficiaries have been paid their share of their estate, they need to consider any tax implications that may arise as a result of their share.